I'm going to call this election board of Lake Bluff to order. It is January 8th, 2020. Could I have a roll call, please?
Kara O'Hara.
Here.
Member Dewart.
Here.
And I am Member Megan Michael and present.
Right. At this point, this is a special body that's been convened for the sole purpose of conducting hearings and making rulings on objections to nominating petitions submitted by candidates for village offices. The membership of the electoral board is set by statute, and members are required to serve unless they have a direct conflict, and neither they are candidates, or either they are candidates whose own petitions are being challenged, or they are running in a race in which their opponents' petitions are being challenged. None of those circumstances exist, and thus the makeup of the Lake Bluff Electoral Board is required by statute to be the village president, the village clerk, and the village trustee who has served the longest, and that is trustee Mark Dewart. The village clerk originally received 4 objections, 3 for candidates for village trustee and 1 for candidate for village clerk. Since that point in time, the objection to the candidacy of Vicki Collins has been rescinded. So now we have we are now down to 2 candidates for trustee, or rather 3 candidates for trustee, I'm sorry. At today's meeting, the electoral board will deal with some preliminary procedural matters, and which we have already done at Monday's meeting. And we will also accept appearances from the candidates, the objectors, and legal counsel. All right, at this point, I will turn it over to our legal authorities to further elaborate on the proceedings.
Thank you. As you said, I think we have appearances from everybody. The case number MOEB 4 was withdrawn. So we have MOEB 1, 2, and 3 to be heard today. For each of these cases, all of the parties agreed on Monday that they would present their cases orally without written briefs. So each of the 3 cases can be heard today. Madam Chairman, do you want me to go through how we'll hear each case?
Go ahead, please.
Okay. For each, we'll ask the board member, we'll ask each party, the objector to speak first, then the candidate will have a chance to respond, and then if necessary, only if necessary, the objector will have a very short period of time to reply if requested and if necessary. At that point, the board, after the oral argument is over, the board will has the opportunity to ask questions of either the objector, the candidate, village council, or village staff. And at that point, once all of that is done, there'll be, in essence, 3 options for the board. The first option would be to entertain a motion to sustain an objection, which would indicate that the objector has satisfied the burden of proof to show why the candidate's nominating papers are not valid and that the candidate's name should be removed from the ballot. That's one option. The second option is a motion to overrule the objection, which would indicate that the objector has not met their burden of proof, and that the board would determine that the candidate's petitions and nominating papers are valid and its name should remain on the ballot. The third option is if for whatever reason the board is not ready to decide today, whether it needs more information from village staff, the objectors, the candidates, or village council, there could be a motion to continue the hearing for further proceedings sometime next week. So that is how they go. Each of those motions would require a second. There can be discussion among the board members once the second is made. And then the votes are by roll call, and the motion, any motion must be approved by at least 2 members of the board. And we'll go sequentially 1, 2, and 3 through the remaining cases. So I'll turn it over to you now, Madam Chairman.
Thank you. Are there any questions by the election board or anyone else for Mr. Friedman at this point? Any clarification? All right, we will now take in the first case in the matter of the objection of Linda K. Hind to the nomination papers of Aaron Toll as a candidate for the office of trustee of the Village of Lake Bluff. At this point, we will hear from the objector. Ms. Hind.
Okay, actually, my attorney is going to be handling this, and that's
Good
Mr.
morning.
Mullen.
Or good afternoon, I should say. This is Ed Mullen here. I have filed an appearance this morning on behalf of Ms. Hind to argue this case. The objection was filed by Ms. Hind challenging the candidate's filing of a receipt for his statement of economic interest. And the Illinois Code requires not only that a statement of economic interest be filed with the county clerk in this case, which would be the Lake County clerk, but in a separate sentence and a separate requirement requires that a receipt for having filed the statement of economic interest with the county clerk needs to be filed with the nomination papers. So in this case, I believe the nomination papers have been admitted into evidence as an exhibit, although I'm not sure which exhibit number they are. But it includes a statement of economic interest to be filed with the county clerk by the candidate, Mr. Toll. And that statement of economic interest is the original statement of economic interest that he filled out and signed. It is not a receipt for having filed that statement of economic interest with the county clerk. I think it's important to note that at the top of that form itself, it says statement of economic interest to be filed with the county clerk. And rather than file that statement of economic interest with the county clerk and then file the receipt with the nomination papers that he filed with Lake Bluff, he filed his original statement of economic interest with Lake Bluff. He did not file that particular statement of economic interest with the Lake County clerk, and he failed to file his receipt for filing the statement of economic interest with the Lake County clerk. He failed to file that receipt with his nomination papers that he filed with Lake Bluff. There is a substantial amount of authority from the appellate courts in Illinois on the failure to file a receipt for statement of economic interest with the nomination papers in a timely fashion. A number of those cases were cited by Ms. Hind in the objection itself, in particular the Bolger case and the Powell case. In the Bolger case, the Illinois Appellate Court for the First District held that the statute, which says you must, quote, must file a receipt for a statement of economic interest, is a mandatory requirement. In other words, it's a requirement that if you do not fulfill it, you are not allowed to be on the ballot. So the Bolger case had made the initial finding that the word must in the relevant statute requires that the statement receipt be filed with the same place that the nomination papers are filed before the end of the filing period. And if it isn't, that is a fatal defect in the nomination petitions and the candidate's name cannot appear on the ballot. Subsequent to that, there was a decision, Powell, that was also cited in the objection, where the candidates were knocked off the ballot for the same reason, failing to file a receipt with the statement of economic interest with their nomination papers. This morning, I forwarded to Mr. Friedman, as the board counsel, a copy of another case that was not cited in the objection, and that is the Kellogg case. I can cite that for the record, but I did provide the courtesy copy of that. That's Kellogg versus Cook County Officers Electoral Board, and that's 647 Illinois Appeal 3rd, 666, an unfortunate number. And that's a first district case decided in 2004. And the reason I decided to forward this case is because I believe that while there are a number of appellate court cases that specifically say that the requirement to file the receipt is mandatory, this case talks about an instance where The statement of economic interest itself was filed in the location where the nomination papers were filed instead of in the location where it was supposed to be filed, and a receipt was not filed with the nomination papers. And the court in that case addressed the plaintiff's argument that by filing the original statement of economic interest with his nomination papers, he provided sufficient information and sufficient disclosure. And the court found that that was not in fact correct, and that the statute required that the original not be filed with the office where the nomination papers are filed, but that the receipt itself is required to be filed with the location where the nomination papers are filed, which in this case is with Lake Bluff clerk, not with the Lake County clerk. So here we have an instance where I don't think it's undisputed that there is not included in the nomination papers of the candidate a receipt for having filed the statement of economic interest. The statute, excuse me, section 10-5 of the Illinois Election Code is absolutely clear that not only does the statement of economic interest need to be filed, but that the receipt needs to be filed with the nomination papers. And those are separate and independent sentences, separate and independent requirements. And the Kellogg case specifically says that where the original of the statement of economic interest was filed with the nomination papers instead of the receipt, that was not sufficient to comply with the standards of the Illinois Election Code. And in that case, the candidate was not allowed to appear on the ballot. There is no case that I am aware of, and there is an Illinois election law book published by Matthias Delort that is well relied on by election lawyers and election authorities throughout the state. And that collects opinions, not only appellate court opinions, but circuit court opinions and electoral board opinions. And in their section on statement of economic interest receipts, which for the record is 1.113, there are dozens and dozens of cases where a candidate is knocked off the ballot for having failed to file their receipt with their nomination papers. And I am not aware of a single case where a candidate did not file a receipt for filing his statement of economic interest with his nomination papers where the candidate has been allowed to remain on the ballot. So not only do you have the specific authority from the Kellogg case, but I don't believe there's any contrary authority where a candidate has been let on the ballot when they have failed to comply with the mandatory requirement of section 10-5 of the Illinois Election Code that they file a receipt for having filed their nomination statement of economic interest along with their nomination papers. So I believe the law, in this case, the statute, section 10-5 and the case law interpreting it are very clear. The candidate has not complied with the requirements for him to be allowed to run for the office of trustee of Lake Bluff, and this board should strike his name from the April 6th ballot on those grounds. Thank you.
Thank you. At this point, we will hear from the candidate. Mr. Toll. Is there a connection problem?
Chair O'Hara, Mr. Toll is connected. He has not turned on his video or his microphone.
Okay. Is there a way to advise him that he needs to do that if he wishes to speak?
The village administrator is getting in touch with him now.
Okay, thank you.
Hi there, can you hear me?
Yes, yes, Mr.
Okay, I apologize. Obviously, I'm at work today, and we just got back from a call for service. So I've missed the first part of the meeting, but I am here now.
Okay, thank you. Thank you. You missed, what you missed were the arguments presented by Mrs. Hines' lawyer, Mr. Mullen. And it is now time for the candidate to be able to present his views or his side. Would you like to do so, sir?
I would. I don't have any legal briefs. I don't have any additional evidence to present, nor do I have any questioning of the objector. All I have is a statement, and I wish to read that, and that will be my submission.
Thank you. Please do so.
So I would normally begin by saying thank you for allowing me the time to speak. But in this case, as I believe most of us can agree, this hearing should never have happened. While I was naive to think that our cherished Lake Bluff bubble would forever protect us from partisan politics, it is now clear that today's national political climate has established itself in our local elections. We often find ourselves searching for candidates to fill empty positions, so the fact that someone would go as far as to file an objection to my candidacy based on a technicality tells me two things. One, I've made some votes over the past 4 years that not everyone agrees with. And two, this objector does not trust her neighbors to vote me out in April. In reference to the objection, having dutifully filed a statement of economic interest with the county for the past 6 years, and even including a statement of economic interest with my petition, I believed that I was in full compliance. And so did the village staff member who accepted my position. My question is this: are we prepared as a community to set a standard for candidates in which not even a professional full-time village employee recognizes when a petition is in compliance? If so, our elected positions will likely only be filled by attorneys and professional politicians, and I don't believe that's what's best for Lake Bluff. To the members of the electoral board, it is your duty to not only protect the election process, but to do so in the best interest of the village. By finding in favor of the objector and removing my name from the ballot, you not only allow partisan politics to discourage good, thoughtful people from running for elected office, but you encourage a level of scrutiny for both the candidates and the village as a whole that is at once unrealistic and unproductive. My fear is that no matter what your decision is today, the idea of volunteering for the village, and especially elected positions, has been tainted, and the only people willing to subject themselves to the partisan politics are the partisans themselves. Thank you, that's all I have.
Thank you, Mr. Toll. Are there any other things? May I, right. Are there any other questions? If the board members have any questions? All right, hearing none.
Yeah,
Oh, I'm
Hold
sorry.
on.
Ms. O'Hara?
Yes, sir.
Attorney Mullen had cited 3 pieces of case law: Kellogg, Bulger, and Powell.
Mhm.
In addition, we've been alerted to Jenkins versus McIlvain. Question to attorneys Friedman and Weiss: are there any subtleties, not as an attorney, obviously, but I would assume that in case law, there must be some subtle difference among the 4 cases here. Is there anything that would be among the 4 which would be pertinent to this particular situation?
I don't believe so.
Okay. All right.
Any other?
I have a question.
Yes, please.
Not having all of those law books in front of me or those cases, is there an example, or are the examples that you presented, Mr. Mullen, are of cases where the candidates who failed to file have filed previously in the past 6 years? Not failed to file, but failed to get their receipt.
Yeah, so in the Bulger case, the candidate did file the statement of economic interest properly with the clerk, but did not file the receipt. So had in fact filed it correctly with the board previous, or with the clerk previously, and just failed to file the receipt. So yes, that would be directly responsive to the question, and that's the Bolger case from the 2nd District in 1991.
But did that candidate also file for 6 years previously in the
I
correct
don't know
manner?
the answer to that. No, but they filed in the same year that they were supposed to file their nomination papers. Yes.
Any other questions? All right, now we have the opportunity for select one of 3 motions. The first motion would be to sustain the objection to the candidacy and would indicate that the objector has satisfied the burden to show why the candidate's nomination papers are not valid and that the candidate's name should be removed from the ballot. The second possible motion could be that to override the objection, which would indicate that the objector has not satisfied its burden and that the candidate's petitions would be deemed valid and the candidate would remain on the ballot. There is a third option. If necessary, we could have a motion to continue the hearing for further proceedings. Clerk, do I have them, by the way, do I have a motion? Of the 3, do I need it? I would need a motion that represents one of the 3 possibilities.
Madam Chair, I'll move to sustain.
All right, do I have a second for that? Not hearing a second for that, do I have a motion to override?
Is this something we can discuss more?
Yes,
Yes.
we can.
All right. I'm having a very hard time with this, as Mr. Toll has correctly filed for the past 6 years and has served our village so diligently. It's very tough to think about on a technicality while legal that we have to make this decision. And I just would like to discuss it more.
All right.
You know, honestly, I find little argument with Trustee Toll's statement. I've been pleased to have served with Aaron for 6 years. I think he has done an incredible service to the community for that particular time. In my mind, there is no ethical question or transgression by any means. Sadly, it's my understanding that based on case law, ultimately, if this goes to, if we were to overrule and this was appealed, it would largely go to, as I understand it, to another party who has little or no connection or tie with the village, and it's going to end up being resolved as a matter of following of case law. And this is all very distressing to me. But it's a very, as I think as Ms. Michael said, this is a very distressing process for me.
I had a statement I was going to read at the end, but since we are discussing now, I'm going to read it now. For 125 years, we have had many contested elections, but to my knowledge, we have no one challenge candidacies of anyone prior to this. The charges levied have not been for any illegal action, but rather procedural. these are not egregious allegations. No one forged a signature or put a dead person on a petition. These errors were made by busy residents who willingly came to volunteer their time to serve our village. Our community deserves to have a choice in their local elections. These challenges do not serve the village well. Who wants to volunteer when they are potentially liable to be scrutinized for minor infractions? And this is a community which runs on volunteer support. I am deeply and deeply saddened by all of this, which in my opinion is not in the overall best interests of Lake Bluff. We'd like to have more discussion from the trustees. All right, I will ask again. We have a motion on the table to sustain.
No,
I have to do that again. What's my
yeah,
procedure?
that motion failed for lack of a second, so it needs
Okay.
to be said again.
Read again. All right, so we'll start from the beginning again and see where we go. Do I have a motion to sustain? Did I hear anything? You know, I have a hearing problem. Did I hear anything?
You did not.
Thank you.
I'll offer the motion again for the purpose of furthering the process.
All right. Okay. Do I have a second for that?
Not going to second that.
What
You
was
said-
that?
No,
Okay.
no,
Did you second that? I'm sorry.
I'm
She did
sorry. No,
not.
I did not.
Thank you. All right. At this point, that motion failed for lack of a second. I will go on to the second option. We could have a motion to override this objection. I ask a motion to override this objection. Do I have a motion?
I'll make that motion to override the objection.
And I second that motion. Would you call the roll, please?
Chair O'Hare,
Aye.
Member Dewart,
No.
and Member Michael as myself, I vote aye.
Motion carries.
So, Madam Chairman, we need a further direction to prepare. Well, I guess we don't need direction. We will prepare a written order that you will have to vote on at a subsequent meeting.
Yes, I understand that. Okay. All right. Thank you. We'll now move to motion 2. In the matter of the objection of Frederick B. Lesser to the nomination papers of Catherine Hatch as a candidate for the office of the village clerk of the village of Lake Bluff. Do we have the objector here to speak today?
Yes, Madam Chair. I am here. I move to withdraw my objections in 20 MOEB 2 and 3.
I missed a big chunk here. When Ms. O'Hare said, call the
Would you like to
roll,
repeat it, Madam Court Reporter?
everything froze up on me.
No problem. It's Zoom is, yes, we're all dealing with it. I am the objector in 20 MOEB 2 and 3. I hereby move to withdraw my objections in 20 MOEB 2 and 3.
All right. Mr. Friedman, what are our procedures on this?
So we can, I assume the board has no objection to accepting that withdrawal, and we will prepare an order for the board to approve at its next meeting, acknowledging the withdrawal of those objections.
All right. At this point, I would open this up for any public comment for anyone wants to speak on this issue. Do we have anybody that would like to do so?
Madam President, Chairwoman O'Hara, I'd just like to remind you that there was a comment circulated via email earlier today that will be part of the record that all of you were submitted.
Thank you.
Madam Chairman, we do need to set a time for your next meeting.
Yes, thank you. We do need to set a time. I'm going to suggest, if with the other two members of the electoral board, that it would be 5:30 on Monday evening, this coming Monday evening, which is January, what is that Monday? We have a board meeting also and a cow meeting. So I would like to set that at 5:30 prior to 5:45 actually, because we don't need, I think, a lot of time with that. At 5:45 on the 11th. Is that acceptable to my two other members?
Yes.
All right, thank you. All right, so then.
Madam Chair,
Yes, ma'am.
Madam Chair, if I might, I'm a member of the public as well as the candidate whose objection has been withdrawn just now. I wanted to thank the board for considering this and taking the time to consider it. I also want to thank everyone who addressed this issue with such clarity and concern. I think we're well served by the decision here today. I'm glad that we're able to move forward, and happy that we can get to the substance, and that we don't go down the road that Mr. Towle was talking about, and that there's nobody is benefited by that. So thank you, and thank you for your service, Mr. Towle. I do appreciate it. It'll be good to get to know you.
Thank you. Anyone else? All right, hearing none, could we have a motion to adjourn?
You know, Madam Chairman, I'd be remiss if I didn't reiterate my concerns. And I guess at the soul of the matter, I share, once again, I share the concerns that you had cited and that Trustee Michael had cited. We're faced with a procedural matter, and we have a long-serving, productive member of our community who has served us and served us in a legislative function for an extended period of time. And it's truly sad that we are not going to be able to continue to enjoy his services and his service to our community over this matter. So Aaron, I bow to you with the greatest respect for your service.
I'll be doing it either way, Mark. Don't worry.
I thank everyone for participating. I thank everyone for their service or who wants to serve, because that is what we're about as a community. There's a lot going on in this country right now. A lot of stuff that I'm probably the oldest person at this meeting, and I have never seen in all my years, and I hope to never see again. But I don't want partisan politics in our local government. That's been the beauty of Lake Bluff, is that we may differ and we may bicker, but eventually we all do come together. We all have the same goals. We may look at them a little differently and sometimes may want to take different paths to get there. But I truly believe that anyone who wants to serve this community has the best interest of this community at heart. And I hope that we can continue in that manner as we move forward. So with that, is anyone else wish to speak? And or not, I would ask for a motion to adjourn.
So moved, Madam Chairman.
Thank you, sir. Appreciate it. And do I have a second?
Second that.
Thank you. This board is adjourned. Thank you all very much.
Madam Chairman, that was all in favor of adjourning.
Oh, I'm sorry. All in, I beg your pardon, everybody. All in favor?
Aye.
Aye. Thank you again, and have everyone have a safe weekend.
Thank you.